Hi guys. So TAG have refiled their motion for summary judgment. Um, I want to start though because I'm sure people will have noticed, but Wayfarer have enlisted 3 attorneys from Alexandra Shapiro's law firm, and I've had a little look, and they are absolute bangers. They are such highly talented attorneys. I think they're in this to win. I really do. 2 of them have clerked previously for the Southern District of New York. One specifically for Judge Lyman, actually. But they have quite the high achievers, definitely. So I'm really excited. I also get the sense as well. One is an appellate attorney. So I do wonder if they are gearing up for an appeal. And I really do think that they're up in their game now as well. And the reason they have to do this in many ways is the SH claims are now being thrown out. I do think Lively will try to appeal. I can see it. But what is still in play is the Section 47.1 motion for damages. That's the treble fees, costs, damages, etc. Now, that is still in play because retaliation is still in play. And as Judge Lyman has helpfully reminded Lively, she believed that she was sexually harassed. Even though the claims are now gone, her belief was, well, he's kind of made the case for it, well, as there was good cause, it was a reasonable basis, etc., etc. So there is still the biggest threat looming in that, Wayfarer may still have to pay her a lot of money if Judge Lyman decides to grant her all of those remedies. But if she doesn't get it, I think she'll appeal. So I think Wayfarer and Wayfarer may be still looking to appeal the dismissal of their own claims too. So there is that. That made me excited. Now, I was a bit surprised we had another filing in addition to the motion for summary judgment from TAC. It's a short letter. Basically, this is a motion from Blake Lively to exclude the testimony of one of Wayfarer's expert witnesses, and that is Nicole Alexander. Well, I haven't read this yet, so we'll just go through it. This might be actually she's looking to seal portions of her motion and some exhibits as well. Okay, we'll read it though. So, on behalf of plaintiff Blake Lively, we write pursuant to Rule 4B of Attachment A of the court's individual rules to respectfully request that the court preliminarily seal portions of Miss Lively's motion to exclude testimony of Nicole Alexander. Now, you remember Nicole Alexander is the tech expert, I guess, if you want to call her that. She was the one who there was that whole kerfuffle over the way the attorneys were fighting during the deposition. There was a delay initially to her deposition being taken because she was unwell. And then Blake Lively successfully requested additional time for her deposition because of the way, I think it was Kevin Fritz. I may be wrong, but it was definitely one of the attorneys for Wayfarer. Well, Judge Lyman, she asked for something, she got it at the end. I don't need to really say much more than that. So it's that expert. And this is one, I think I did like a long series. There may have been 10 or 12 episodes where I spent ages going through the entirety of her deposition transcript. And I was incredibly critical of her knowledge. I really was. I thought that she was not going to be a good witness for Wayfarer. I still do. Nothing's changed my mind. However, I have seen I have read some of the reports from Blake Lively's witnesses, and I think there are problems with some of them too. But let's continue. Let's just see. So she wants to seal portions of her motion to exclude testimony of Nicole Alexander, as well as a load of exhibits filed contemporaneously herewith. As previously ordered by the court, Ms. Lively has redacted personal identifying information, including phone numbers, email addresses, and online usernames from these materials, and asks that any such PII be permanently sealed. Ms. Lively has also filed several materials, including Ms. Alexander's report, her backup materials, and any materials directly citing or quoting the report under seal because they were originally designated by defendants as attorney's eyes only. Ms. Lively has filed them under seal out of an abundance of caution, even though the report is derived entirely from public sources, and we do not concede that the report or its supporting materials are properly marked as attorney's eyes only. In accordance with Rule 4B of Attachment A in the court's order, Ms. Lively respectfully requests that the court not rule on this letter motion to seal for 1 week, so that Ms. Lively and the defendants have the opportunity to meet and confer, and the parties and or any third parties may file a motion for continued sealing if they so choose. Footnote here. So Ms. Lively attempted to obviate the need to seal her Daubert motions. Remember, Daubert motions are they're relative to expert testimony, reports, etc. To seal her Daubert motions by requesting that the defendants de-designate their expert reports, deposition transcripts, and backup materials as to specific experts. At 12:34 p.m. on April 10th, 2026, counsel for the defendants refused to de-designate any of these materials based on the assertion that Ms. Lively was unwilling to meaningfully confer, and the factually inaccurate claim that Ms. Lively had essentially given us nothing because she previously had de-designated materials only for 6 of her experts, but not for all of them, specifically the ones that contained confidential business information and or content designated by third parties. Okay, so we know that motion is coming in. So we know that motion is going to come in, and that's Blake Lively just looking to seal some various things. Okay, so is this the right one? No, this is the notice. Okay. Okay, so this is not too long. Okay. As authorized by the court, so this is TAG's motion for summary judgment, their refile. As authorized by the court during the conference on April 2nd, 2026, defendant TAG submits its memorandum of law in support of TAG's motion for summary judgment on plaintiff Blake Lively's 7th cause of action for aiding and abetting of retaliation in violation of the California Fair Employment and Housing Act. Introduction. Lively's attempt to impose liability against TAG under FEHA suffers from a fatal flaw. FEHA liability has historically been applied only in scenarios that involve employment-related activities, such as hiring, compensation, and workplace standards. As discussed further below, the crux of a claim under FEHA is the employer-employee relationship. Both the language of FEHA itself, as well as the cases that have evaluated who is liable under FEHA, either directly or as an aider and abetter, establish that FEHA's purpose is to protect employees who are subject to discrimination, harassment, or retaliation in connection with their employment relationship. By contrast, TAG is a public relations firm retained by defendant Wayfarer Studios to protect its reputation, that of its co-founder Justin Baldoni, and that of the film It Ends With Us, in which it had invested millions of dollars. Tag was not involved in Lively's hiring, compensation, workplace standards, or any other employment-related matters. That's fair. I love it. That's a good argument. Based upon the precedents discussed herein, Tag cannot be liable under FIHA because its role with respect to the issues herein was entirely separate from the employer-employee relationship. It would be especially harmful for at least two public policy reasons to hold Tag potentially liable under FIHA. First, liability for retaliation under FIHA has historically been restricted to activities involving the employer-employee relationship. Therefore, permitting a claim to proceed against Tag involving a FIHA violation would be fundamentally unfair. More importantly, such a decision would set a new precedent that an entity completely outside the employer-employee relationship could face future liability for retaliation under FIHA. This would have an understandably chilling effect on not only public relations firms, but also any other company that renders services for an employer. For good reason, companies would be reluctant to provide services that could somehow be held to adversely affect one or more of the employer's employees and potentially lead to liability against the companies under FIHA. Finally, Lively's effort to impose backdoor liability via an aiding and abetting claim against Tag when such liability cannot attach directly should also be rejected. As discussed below, the cases examining aiding and abetting of a FIHA violation are similarly confined to the employer-employee context. Courts do not deviate from the employer-employee relationship when it comes to imposing aiding and abetting liability under FIHA. For all these reasons, Tag's motion for summary judgment on the seventh cause of action for aiding and abetting retaliation in violation of FIHA should be granted. Okay, so we have statement of facts regarding Tag. I'm going to read it because it's not long. Okay. There's a footnote. This statement of facts is an abbreviated version of the more expansive statement of facts contained within Defendant's Memorandum of Law. Okay, so the November one. Okay. So, in 2019, Baldoni obtained the rights to produce a film based on Colleen Hoover's best-selling novel, It Ends With Us. In December 2022, Lively, a well-known prominent actor, was cast as the female lead. After completion of the film, during which various conflicts between Baldoni and Lively arose, Lively took steps to damage Baldoni's reputation. They're alleging that she smeared him. Including 1. Unfollowing Baldoni on social media, encouraging the press and fans to suspect a feud. And it's important to remember that that particular tactic has been previously used by Lively and Reynolds and Taylor Swift, because that is exactly what they did to Joe Alwyn when Alwyn and Swift broke up. Was they kind of all mass unfollowed, and Lively's admitted to getting co-stars from, I believe it was Gossip Girl, to do a similar thing to, I believe it was Penn Badgley, before she got to know him. She took a dislike and got her castmates to kind of, be distant from him, not follow him, etc., etc. But I know when Swift and Alwyn broke up, there was a news article about how they all kind of suddenly unfollowed Joe Alwyn to make it look like he was the problem, which is exactly what circulated in the media. So this is a playbook thing that they do. And we know from Colleen Hoover's deposition that she unfollowed Baldoni because she was asked to do that by Blake Lively. Why? Because she's a twat. Okay, back to this. All right, so unfollowing Baldoni on social media, encouraging the press and fans to suspect a feud. As I said, exactly what they've done to Joe Alwyn. 2, having her husband, Ryan Reynolds, tell their famous Hollywood friends that Baldoni belonged in jail. 3, Having Reynolds tell the executive chairman of WME, a powerful talent agency that represented Baldoni at the time, that Baldoni was a thoroughbred predatory fraudster. 4. Telling Colleen Hoover and another prominent author that Baldoni was a narcissist. And 5. Telling Sony, which co-produced and co-financed the film, that she would not attend the film's premiere if Baldoni was also present. I mean, when you put it like that, you get a flavour of how this is going to be presented to the jury, and put like that, that is a lot more to the point. It's a lot more blunter language than we have previously seen in filings from Wayfarer, where they have tried to be, we're the nice people here, and they've tried to maintain that. But I think someone may have sat them down and gone, right, okay, all of these claims are gone, great, but now we need to take this serious, we need to get serious and we need to fight. And if someone has done that, great. Because I prefer this word, and it is to the point, and it should leave Lyman in absolutely no uncertain terms of their position. And then hopefully when it comes to trial, they will do the same thing there. In July 2024, in response to Lively's tactics preceding the premiere of the film, Baldoni and Wayfarer entertained the concept of hiring a crisis communications team. On July 25th, 2024, Baldoni met with TAG to discuss retaining the firm for crisis management. Wayfarer reiterated that it did not want to take any offensive steps, and that TAG's principal, Melissa Nathan, would not be having any comms outside of our internal teams. On August 2nd, 2024, TAG circulated a scenario planning document listing a series of possible options for responding to the public relations crisis facing Baldoni and Wayfarer. After media outlets began publishing stories about the feud between Lively and Baldoni, Baldoni's public relations team, including TAG, distributed positive information and stories about Baldoni and worked to mitigate or minimize negative ones, standard operating procedure for public relations professionals. TAG was not involved in any FIHA-regulated activities on Wayfarer's behalf or on behalf of defendants in Ensworth's movie. Regarding Lively, including her hiring for the film, her compensation, services to be rendered, or the maintenance of workplace standards. Argument. TAG cannot be held directly liable for retaliation under FIHA because it was not involved in any FIHA-regulated activities. And I've said this a lot about Jed Wallace as well. When I read the Texas filings, Lively, because when you separate the defendants, you actually see the crux of the arguments against them specifically, and you hear their defenses and counter arguments, which is more specific when it's just one defendant versus 8 collective defendants. And one of the things that really bothered me about Lively's attempt to pursue Jed Wallace, including for section 47.1, was he was nowhere near the set. He did not sexually harass her. He didn't get involved until, over a year after her allegations of sexual harassment. So how can you be suing a guy, for retaliation for something he was not part of? What motive would he possibly have to get involved in that? It did not make sense. And the same thing is bothering me with Melissa Nathan, with TAG, and with Jen Abel for that matter. So I'm glad they're kind of taking this approach, because I don't think this was overly teased out in the collective filings in the original November motion for summary judgment. It wasn't overly teased out, the position of the PR girls and TAG. So I am happy to see this. Okay. In its recent opinion and order, the court noted that there is reason to believe that aiding and abetting liability applies to business entity agents because, 1, business entity agents can be directly liable for substantive FEHA violations. And 2, the California Supreme Court treated issues of direct liability and aiding and abetting liability similar in Reno. However, as explained below, business entity agents are only directly liable for substantive FEHA violations when they carry out FEHA-regulated activities, which Lively neither alleges nor demonstrates with respect to TAG, because TAG is merely engaged in public relations activities. Furthermore, the California Supreme Court's similar treatment of issues of direct liability and aiding and abetting liability compels a conclusion that TAG cannot be held liable under FEHA because a predicate for direct liability is the defendant's engagement in FEHA-regulated activities. TAG did not engage in any FEHA-regulated activities with respect to Lively. Okay. Liability under FEHA requires a nexus to an employment relationship. The fundamental foundation for liability under FEHA is the existence of an employment relationship between the one who discriminates against another and that other who finds himself the victim of that discrimination. As stated in FEHA itself, the employment relationship is key. It is hereby declared as the public policy of the state that it is necessary to protect and safeguard the right and opportunity of all persons to seek, obtain, and hold employment without discrimination or abridgment on account of race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, sexual orientation, reproductive health decision-making, or military and veteran status. The California Supreme Court has consistently interpreted FEHA in the context of the employment relationship. In Reno, the court examined whether individual supervisors may be held liable for discrimination under FEHA. The Reno court held that no liability for discrimination under FEHA could attach to supervisors, because doing so would place a supervisory employee in a direct conflict of interest with his or her employer every time that supervisory employee was faced with a personnel decision. It would coerce the supervisory employee not to make the optimum lawful decision for the employer. The Reno court similarly held that it was not concerned about opening the floodgates of discrimination by absolving individual supervisors of liability for discrimination under FEHA because the supervisor's employers would remain liable. In Jones, the California Supreme Court examined whether it would extend its holding in Reno to personal liability for retaliation as well. In extending this protection from liability for retaliation under FEHA, the Jones Court adopted the reasoning of Reno wholesale, noting that all of the reasons for not imposing the individual liability for discrimination apply equally to retaliation, including sound policy favors, avoiding conflicts of interest, and the chilling of effective management. Corporate employment decisions are often collective, and it is bad policy to subject supervisors to the threat of a lawsuit every time they make a personnel decision. Again, the California Supreme Court interpreted FEHA through the all-important lens of an employment relationship. Direct liability under FEHA for business entity agents is limited to those which carry out FEHA-regulated activities. In Raines, the California Supreme Court examined whether a business entity agent may be held directly liable for discrimination under FEHA. The Raines Court held that it could, but it expressly limited such potential liability to appropriate circumstances when the business entity agent carries out FEHA-regulated activities on behalf of an employer. The Raines Court ruled that, as a necessary minimum, consistent with FEHA's language and purpose, a business entity agent can bear direct FEHA liability only when it carries out FEHA-regulated activities on behalf of an employer. In other words, according to the Raines Court, a business entity's agent obligation to comply with FIHA and its consequent liability for FIHA violations results from the entity's own engagement in FIHA-regulated activities on the employer's behalf. So I know in his judgment, part of the reason Lyman kept her in and said, we can refile, is because, he dismissed Nathan and Abel because you couldn't hold employees liable, which makes complete sense. But also, TAG remained because they are a business entity and they carry out FIHA regulated activities in general. They are FIHA compliant. What Wayfarer are basically saying there with those judgments is that yes, but TAG is not a FIHA is not engaging in FIHA regulated activities on Wayfarer's behalf, i.e. they had nothing to do with Lively's employment, which makes perfect sense. It's a good argument. I don't know if Lyman will accept that, but it's a logical stance. Although the Rains Court did not define FIHA-regulated activities, the context in which Rains was decided, the screening of potential employees for hiring, demonstrates that the activities in question are the traditional activities performed by an employer in an employment relationship. This is consistent with analogous case law interpreting Title VII of the Civil Rights Act of 1964, for which courts have held that an employer's agent may be independently liable when the employer has delegated to the agent functions that are traditionally exercised by an employer. So that'd be like if you got an outsourced HR or payroll. That's when you'd expect that situation to arise, but that's not what TAG's function was. This is also consistent with the California Supreme Court's prior holdings in Reno and Jones, in which the employment relationship formed the crux of the court's holding. TAG is not liable for aiding and abetting a violation of FIHA. The case is examining whether a business entity agent may be held liable for aiding and abetting a FIHA violation, also uniformly deal with conduct involving employment-related activities. Thus, TAG, which was indisputably not involved in any employment-related conduct, cannot be held liable for aiding and abetting a violation of FIHA. In Ouch, the California Court of Appeal examined whether certain talent agencies for television writers could be liable for allegedly assisting networks and studios in engaging in age discrimination. In finding that aiding and abetting liability under FIHA could attach to the talent agencies, the court held that the complaints adequately alleged that the agencies knew the employers were engaged in systemic discrimination on the basis of age, and gave substantial assistance or encouragement to such conduct by virtue of their own referral practices, screening out older writers in favor of younger ones. In other words, the talent agency's own employment-related practices, i.e. screening out older writers and referring younger writers, triggered the agency's potential liability for aiding and abetting. In Malekzadeh, I don't know if I'm saying that right, the plaintiff alleged that his employer, Costco, discriminated against him by failing to provide reasonable accommodation for his disability. The United States District Court for the Northern District of California found that plaintiff had alleged a colorable aiding and abetting claim under FIHA against the agent retained by the employer to manage its disability accommodation program, where Rehab West attended and facilitated job assessment meetings and determined that plaintiff could not perform essential job functions. Nothing in these cases, or in the language of FIHA itself, suggests that a public relations company like TAG should be held liable under FIHA by the roundabout method of aiding and abetting language. There is no evidence that TAG engaged directly or indirectly in any employment-related practices, as was the case in Out and Malik Zadeh. To the contrary, the evidence demonstrates that TAG simply engaged in public relations work for Wayfarer and Baldoni after Lively's work on the film ended. Moreover, there is no evidence that TAG encouraged Wayfarer, which did not even employ Lively or contract for her services, to do anything concerning Lively's working relationship with Wayfarer. As the court recently noted, the retaliatory smear campaign is alleged to have begun after Lively's working relationship with the Wayfarer parties concluded. Importantly, at least one federal court in California has stated that California Government Code Section 129401 was intended to prohibit employers from aiding and abetting third parties such as customers or suppliers, not from aiding and abetting themselves. FEHA focuses on prohibiting improper conduct by employers, not third parties. In other words, FEHA prohibits employers from aiding and abetting third parties, not the other way round. Although the court's recent opinion and order cited 2 cases pertaining to aiding and abetting liability under FEHA, those matters involved defendants who were alleged to have participated in employment-related conduct and stepped into the proverbial shoes of employers. In Smith, plaintiff's employer Jiffy Lube held a presentation for its employees to learn about a new Castrol product. Plaintiff alleged that at the presentation hosted by his employer, a Castrol representative made several comments to Smith that were racist and offensive. Plaintiff commenced an action alleging, among other things, that Castrol and its representative aided and abetted Jiffy Lube's harassment and discrimination of him in violation of FEHA. In liberally construing the allegations, the California Court of Appeal inferred that Castrol's presentation was intended to ensure that Jiffy Lube's employees knew how to properly use Castrol's product, thereby promoting it. Significantly, the court determined that in this context, Jiffy Lube's employees, including plaintiff, were effectively Castrol's clients, patrons, or customers. In Mobley, defendant Workday provided human resource management services, including applicant screening services, to businesses in various industries. After plaintiff was denied employment for over 100 positions to which he applied through Workday's system, plaintiff asserted a claim against Workday for aiding and abetting discrimination under FEHA, alleging that Workday's algorithm-based applicant screening tools discriminated against him based upon his race, age, and disability. In stark contrast to these 2 cases, there is no contention, let alone evidence, that Lively was TAG's client, patron, or customer, as was the case in Smith, or that TAG provides human resources services, as was the case in Mobley. And that's what I said earlier. You know, if you're outsourcing employment-related activities to, for instance, a HR firm, an external HR firm, or payroll company, then, you know, I could see how FEHA could apply. And this case here, one of the ones that Lyman specifically pointed to, is exactly that, a human resources service. TAG has not located any decisions from a California court or any other court holding that a business entity agent can be liable for aiding and abetting a FEHA violation where the business entity agent does not engage in any employment-related activities. It is respectfully submitted that the court should not create new law for the state of California. So that's basically, Lyman, you don't know what you're talking about. Love it. And then they cite courts for that as well when methyl tertiary butyl ether products. Yes, that's a court. Basically, the decision on that was federal court may not adopt innovative theories without support in state law or distort existing state law. There's another case as well. Acoff Ortega. Federal courts do not create state law. Banco Nacional de Cuba. Federal courts must follow and not make New York state law. Conclusion. I love that. They put Lyman in his place a bit there. It's like literally, stay in your lane. Conclusion. For the foregoing reasons, the court should grant summary judgment in TAG's favour on Lively's 7th cause of action for aiding and abetting retaliation under FIHA. And that was Kevin Fritz. Loved that. Wow, that was such a good filing. Lively is going to respond next Friday. I really can't see what she's going to come back with. There was literally no case law that, supported the position that, specifically in regards to PR firms, that they, can be held responsible for aiding and abetting FIHA, under FIHA. But also what they did, so Lively cannot go and find specific case law that will support her position. Wayfarer clearly said there is none. But what they did was they found cases which they were able to attack and say, well, this doesn't apply because of this, and this doesn't apply because of that. But they went one step further and then took apart Judge Lyman's the cases that he cited to specifically. So I couldn't even be trying to imagine what Lively's argument is going to look like. She'll make one. It will probably be an incoherent word salad, but it will be entertaining nonetheless to, sit and read to you guys. But yeah, okay. So I'm really hopeful. She should TAG should actually be successful in getting out of this too. And then if that happens, what is there, only 2 claims left? Hardly worth going to court for. But we'll see what happens. We are still waiting for the pretrial orders to come in, the motions. I will probably get to them tomorrow because it is getting late my time here now. Thank you for listening. As always, please do like and subscribe. Always helps my channel out. I will see you guys later.